Hey, my name is Ben Hixon. I'm a candidate for the Virginia Senate. I'm running against Senator Bryce Reeves. And I want to take a little bit to talk to you about the Equal Rights Amendment, the ERA. Now, this just passed the Virginia Senate, even though my opponent voted against it. All right, but it died in a House subcommittee. So I'm going to explain to you why we need it, why it should be reconsidered by the full committee, and why it should pass. So why do we need the Equal Rights Amendment when we've already got the 14th Amendment, the Equal Protection Clause, that says that nobody can be denied equal protection under the law? Well, the reason is that the Supreme Court of the United States does not interpret the Equal Protection Clause equally. It doesn't interpret it strongly enough to protect women. So as you know, the Supreme Court decides whether or not a law is constitutional. And if it's not constitutional, it gets thrown out. Now, when it decides whether a discriminatory law is constitutional or not, the Supreme Court uses a set of three tiers. Three tiers. Rational basis, intermediate scrutiny, and strict scrutiny. Now, strict scrutiny is at the top. It's the strongest. If a discriminatory law falls under strict scrutiny, then it must be, number one, it must be necessary for a compelling state interest, and number two, it must be as narrowly tailored as possible. Okay? One tier below that, intermediate scrutiny. That just says that the law needs to be substantially related to an important state interest. Okay, so not as strong, not as likely to get thrown out. So let me give you an example. Smoking age or drinking age. If the state says, well, white people can drink and smoke when they're 18, but everybody else has to wait until they're 21, well, that's discrimination based on race. It's strict scrutiny. It's going to get thrown out. Same with religion. State says, well, Christians can drink or smoke when they're 18. Everybody else has to wait until they're 21. Discrimination based on religion, strict scrutiny, thrown out. Sex. State says women can smoke or drink when they're 18. Men have to wait until they're 21, or vice versa. Intermediate scrutiny, not strict scrutiny. That's probably not less likely to get thrown out because it doesn't have the same protections. The Supreme Court does not protect sex as strongly as it does something like race, religion, or country of origin. That's why we need the Equal Rights Amendment. Law should be sex blind. Right, law should be sex blind. Sex should not be a factor in lawmaking. What's in our pants, frankly, is none of the government's business. So that's why we need the Equal Rights Amendment. So let's get it passed. Let's get it reconsidered by the full committee. Let's get it passed. Let's get this done. Thanks. This is Ben Hixon.